going to moderate today's session. I wish everyone that has joined to listen, and I'm also here to learn, and I hope we'll all gain a lot from the discussions of today. So I welcome you to today's enlightening session, and I wish all of us a productive and an educative afternoon. Thank you. Over to you, Safia.
Thank you so much. Thank you, Madam Chairperson, for giving the opening. This is indeed a very interesting and a timely topic, and we're excited to be here. Thank you to our speakers. Good afternoon, everyone. My name is Safia Mohammed. I'm privileged to be moderating this very timely discourse. Now, we know that there's been a lot of happenings in the power sector, and this discussion couldn't have happened at a better time. The power sector sits at an intersection of constitutional law, regulatory practice, and commercial reality. With recent constitutional amendments empowering states to regulate electricity, there's been a lot of happenings in the sector. The emergence of new market structures, increasing private sector participation, we're witnessing a fundamental transformation of Nigeria's energy landscape. And today we're privileged, we're honored indeed, to be here with very esteemed experts in the field. We have the learned Silk, Barrister Ajembe Eko, and Mr. Dafesi Akweneye. I'll just run through a brief profile of both of our speakers. Thank you again for being here. Mr. Ajembe Eko was called to the Nigerian bar in 2005. Prior to his call, Eko joined the law office of Uja & Co. Makurdi in 2003 as a legal assistant, where he laid solid foundation in solicitorship. He has worked as a volunteer staff on contract engagement with the Department of International Development, DFID's Access to Justice Program, as a program research officer. He had a stint with Ndefo & Co. in Makurdi 2006 as an associate, where he was exposed to intense commercial practice. He's a seasoned lawyer with significant experience in project management. His deep resource wealth took him to Starcoms. He honed his litigation skills in the law firm of Dr. J.Y. Musa SN & Co. before he opened his private practice. As a consummate and versatile lawyer, Oko has a number of published works. He's a notary public who commands membership in professional bodies such as the NBA, the International Bar Association, Benue Corps Members of Mediators, Nigerian Institute of Management, Chartered Institute of Personnel Management, Chartered Institute of Arbitrators, UK, Chartered Institute of Management. He holds a Master of Law degree and a diploma in corporate and commercial law and postgraduate certificate in international business law from the University of London. And he's presently undertaking his doctorate degree program at the Euclid University and also undertaking another degree program at Weldon University. He's also a chartered arbitrator and a dispute resolution practice. His practice interest includes general practice with a bias for litigation, labor law, corporate law, and commercial law. We're pleased to have you join us. You're welcome, Leonard Silk.
It's indeed my pleasure, Safia. It's my privilege to be here, and I'm honored that you can have me.
Thank you, sir. And we know that at this time, it is very, very important to not only know what is going on in the power sector, but to hear from the regulators. And to that, we have the honor of having the Commissioner for Legal Licensing and Compliance of the Nigerian Electricity Commission join us, Mr. Dafesi Akweneye. He's the commissioner and he heads the Legal Licensing and Compliance Division at NEC. In this role, he's primarily responsible for issuing licenses to participants in the NESI, that is the Nigerian Electricity Supply Industry, enforcing the provisions of the Electricity Act and resolving industry complaints and disputes. He graduated from the Obafemi Awolowo University with Bachelor's of Law in 2001 and was called to the Nigerian bar in 2003. He worked briefly with the firm of Jude Idegbe & Co. before proceeding to join Ibrahim Yakubu & Co. in Lokoja for his NYSC. After which he joined the legal law firm of Ajimogobi & Okeke, and upon his return in 2004, he worked at the PwC, PricewaterhouseCoopers Global Network of Firms in December 2005, where he led the regulatory services practice at PwC Nigeria and was also the general counsel of the firm in Anglophone West Africa until his resignation on the 31st of January 2017 to take up the role at NEC following his nomination as commissioner by the President Muhammad Buhari in July 2016, and subsequent confirmation by the Senate in January 2017. He is a member of the Nigerian Bar Association, the Chartered Institute of Taxation, and the Chartered Institute of Arbitrators. Mr. Dafe is a two-time commissioner at the Nigerian Electricity Regulatory Commission. Mr. Dafe, congratulations again on your appointment. It is well deserved, and we're happy to have you join us. You're welcome, sir.
Thank you very much. Good afternoon.
Thank you for joining this timely discourse. So I'll go straight into the questions. And so, Commissioner, I'd like to start with you. I'd like you to give us a background on the current regulatory structure under the Electricity Act.
Okay, thank you. That's a rather broad question. But before I go into it, I think it's pertinent to correct something, since this is a group of lawyers having a discussion as lawyers. And you said the recent constitutional amendment empowered states. States have always been empowered to regulate the power sector. So the provisions in the 1979 Constitution, from 1979 to date, have remained largely the same. States have always had the powers to regulate state-owned electricity markets. But there was a previous misconception that they couldn't do that because of a section that says in the areas not covered by the national grid, right? But when you look at the Constitution, in the concurrent list, it's bifurcated, right? It goes on to state what the federal can do, meaning that we can regulate generation, transmission. There's no distribution, only for FCT, right? We can set standards. We can do inter-country, right? And distribution would only involve where it's going into another country, right? So states have always had that power, right? Nothing has changed. And in fact, one can even argue that the federal government, and indeed NERC, has no jurisdiction over downstream issues like distribution, because that's what the Constitution says. So, but as my people say where I'm from in the country, anytime you wake up, it's morning. So there's now an increased interest, and what the Electricity Act does, it creates a mechanism by which regulatory powers can be transferred from the central regulator that I work for, NERC, to a state regulator. I've argued in setting forward that because states derive their powers from the Constitution, right? They don't need anybody for an orderly. So that the provisions of the Electricity Act, to me, are just gentleman transactions provisions for orderly transition. Because if the Constitution gives a state power to do something, nobody can challenge what the powers that you've been given. So the framework we have now is we have a framework whereby you have a central regulator responsible for the national grid, right, and the wholesale electricity market for Nigeria, and you have state regulators in states that have created their regulatory frameworks to run those markets. So mainly the first group of states to start that were Enugu, Ondo, Ekiti, Edo, Ogun. But in Edo and Ogun, the institutions haven't been really formed at this point in time. So of the states that I mentioned, Enugu appears to be at the forefront because they're fully constituted and they are running. So the regulatory framework we have now is you have a central regulator in Nigeria, being NERC, responsible for the wholesale market and the entire country, right? Then you have states that have formed their own regulators, right? Yes. Now, anyone who understands the way this works is if you see that, wait a minute, this is a constitutional matter in which the federal government doesn't really have federal doesn't have jurisdiction over certain matters, right? And you do not have, and it's not, that means you cannot have an elective regime, right? You cannot decide what to do and when to do it, right? So you now have a central regulator that has been regulating the entire market, right? And states going at their own pace. So you have an issue now, right? Whereby you have some states that have gone, right? Lagos, Ogun, Ekiti, that have gone on their own, right? And you now have some states that are still in the pot, right? So we have like three systems, right? You have one, the federal government, NERC doing this wholesale market. You have states that have taken responsibility for their electricity markets in their states. And I'm using that word advisedly here. You can only administer a market, right? You cannot specify standards. The standards are specified by the central regulator. So you cannot say you want to operate at 220 volts, at 110 volts, right? So all standards are centrally specified, and those powers are vested in the central regulator, NERC. So what you can do is you can license people in your market, you can regulate activities in the interstate market, but they have to conform to standards that are the Nigerian standards as specified by NERC in the Constitution. Then you have the third bucket in states that haven't gone, right? And that is, you now have the commission responsible for handling those activities like we did before. So that's where we find ourselves now in that, from a regulatory standpoint in Nigeria today.
Thank you so much for shedding light. It's important that you stated that states' powers is not new. It has always been there. It's just that it's just becoming interesting, and we're beginning to see more investment and transition in that field. So my next question, we go to the learned talk. Building on this regulatory framework from a constitutional perspective, how has this changed, this recent transition in regulation of electricity sector? How has it shaped the legal architecture? What principles do you think should guide the courts in resolving disputes that stem out of this? Because I envisage that there's going to be some dispute based on this transition. What principles do you expect that the court should use in resolving disputes of such nature?
Well, issues of this nature are not new to the courts. Issues of shared jurisdiction between the federal level and the state level is not a new kettle of fish for them. But I understand for the power sector, they have the Electricity Supply Practice Direction 2026, which is still in its formative stage. If my information is correct, that practice direction is supposed to be gazetted anytime now. And when that is done, that comes out to guide lawyers how to file matters relating to power sector, especially between licensees and consumers and licensees, and the usual thing we have all the time, which is between consumers and the distribution companies, because they make a majority of most of the complaints in the power sector. Issues of jurisdiction, the first thing the court takes into consideration is where the cause of action occurred. So I don't expect somebody filing a matter in Abuja when the facts surrounding the cause of action took place in Lagos or Ogun or Sokoto, for instance. So if the question has to do with what modalities the court look into in deciding how they handle these issues, it's straightforward. It's not new. So it's a question of how the people bringing the complaints are to be guided, how they bring these complaints forward. And good enough with it. I think, NEC, you guys have done marvelously well, because I understand that the practice directions was actually their brainchild, so to speak. So with the gazetting of all that, it streamlines issues.
Okay. Thank you, Leonard. So we see that from the practice directions, when it is gazetted, we're going to see more details into it. And we believe that would ease off the cases in court and indeed give us a way forward on how to do, what to do, when to do it. So thank you for that point. And my next question will go to Commissioner Dafe. Now, you've mentioned that there's a centralized system in terms of setting of standards. And I want to say, other than setting standards, will there be a separate licensing procedure for state markets? And if any, what is it going to look like?
Okay, thank you very much. State markets would be regulated in accordance with state law, right? And there isn't a uniform state law. I would have thought the best, I think the main issue to have addressed that would have been the Electricity Act itself and why it's being amended, right? Why there's a need for a piece of legislation that was only signed into law in 2023 is being pushed. There's a push for an amendment now. When you look at the Electricity Act is the only piece of legislation that twists the principle of covering the field on its head, whereby primacy, I think it's section 4 or so of the Electricity Act, it gives primacy to state law over the central law, and that doesn't occur in a jurisdiction that operates a federal constitution like ours. So there's a need to ensure that the field is properly covered, right? And what covering the field does because Nigeria is very big, Nigeria is a very large country, right? And over 200 plus million people. You need to have certainty. And the reason why we do not have power the way we want it, at the level we want it, is because we've not invested at the scale in which it's required. And one of the key elements for any investor before you make an investment decision is you must be certain. There must be certainty, right? So you now have various states passing different laws with different understandings, right? And some states even in their laws empower them to take over assets. So there's some expropriation mechanisms in place that you can take over assets of operators in that area. And I don't think our constitution contemplated that because you've been granted powers, you can go and expropriate people's assets without complying with the provisions of the Constitution. So from a licensing framework, yes, states would issue licenses for operations, for intrastate operations, right, in their jurisdictions. So distribution is purely an interstate operation, so that falls within the jurisdiction of the states. Captive generation would fall within the jurisdiction of the states. Embedded generation will fall within the jurisdiction of the states. Now, you don't have situations whereby you have hybrid transactions, whereby you're relying on the grid for supply, right? So if you're relying on the grid for supply, that party needs to be, because that transaction is regulated by NERC. Anything having a touch point to the national grid is going to be regulated by the central regulator. So the central regulator needs to get involved. And the extent by which you play on the national grid, right, will now determine whether NERC should license you as well, right? Or you should be primarily a NERC licensee. So we're going to, as these are early days, but we're going to have scenarios whereby you're looking at who the licensee is, right? Is it a federal activity or a state activity? And you're also looking at transactions. Where is the transaction occurring? Is it an whole interstate transaction, or is it an interstate transaction? So that was what will guide the licensing frameworks. But we are, as the Commission, are developing a matrix to guide that, because minus where the transactions occur, you now have transactions that occur wholly within a state, right? But under law, that location is not within the state. So I'm talking about free zones, right? So if you're doing an activity in a free trade zone, right, that is not an activity under Nigerian law that is deemed to be within the purview of the state, right? It's deemed to be within the purview of the federal government. So for regulation, right? That should fall within the ambit of the commission. So it's early days, and the frameworks will be developing. But the activities, what you can do, the Constitution gives us guidance clearly on what, who's responsible for what, weights and measures, standards, and things like that. And but states will be responsible for things within their markets. So a state cannot specify that this is the type of meter we want in the state, right? Because meters falls within, it's a standard issue, it's an engineering standard issue that it's for the federal government to specify. A state cannot specify that this is the type of conductors we want in the state, because the definition of conductor specifications is a federal issue as well. So these are early days, and that's how we look at things as they evolve.
Thank you, Commissioner. And it's a privilege indeed to be informed now that there is an amendment to the Electricity Act, which was passed just barely 3 years ago. So we are happy to hear that there is a new amendment, and we know that it's going to.
Sorry. I said there's an amendment that is being worked on now.
Yes,
so the amendment hasn't been passed. So we're not aware of what happened. I think the news was misinterpreted, because when I heard that, I had to contact the Senate Committee on Power and the House Committee on Power, and they haven't passed anything. So I think old news was just repeated, because we don't know what was passed, and we don't. So the amendment that's being worked on is still work in progress, and I think we should be going into public hearing in this month or next month.
Thank you for that clarification, because we had previously seen or heard that there's an amendment, and we're happy to hear from you that the amendment is still in the works, and we know that you're going to keep us abreast of happenings, and we're going to get to know what is going on. Thank you so much. And to our participants, thank you for staying on. I would want to encourage us to please drop your questions. This is the time to drop your questions so you can have our distinguished guests answer them. So please drop your questions and we'll take them after the session. Thank you. My next question goes to you, Commissioner. You have mentioned, scenarios on licensing and then transition. So my question is, how do you handle transitions from evolving licensing? For instance, hybrid systems transitioning to off-grid, connected operations, license transfers. How do you handle that?
So I think that's I don't know, your question is a bit. So when you say hybrid systems, that's it entails a lot. So the issue is that let's break it down into very simple terms, right? So who has jurisdiction? So that is always a good place to start with, right? When you look at the Electricity Act and the Constitution, like I rightly said, right, distribution doesn't fall within the purview, right? So I'm only responsible as the Commission, as NERC, for distribution over the FCT, because the Constitution says the federal government is the responsible for laws in the FCT. So for other parts, right, let's take Niger and Kogi, that are part of the AEDC network, and they've transitioned, right? So distribution is now a local matter, right? So things like end user tariffs and things like that, it is the local state regulator, right, that licenses and regulates that activity, right? So depending on what it is you're doing, right? If you're a captive provider, right, you're using your own generator to provide power for yourself, right? Above the threshold specified in the law, that is a state responsibility. So looking at who gets to license, if it's an activity that will cross the boundaries of one state to another state, that is for the federal government and NERC to regulate. So you need to look at it from a jurisdiction standpoint. Where would the activity occur? And that will now determine who regulates that activity and who licenses that activity.
Thank you. Thank you so much for that, Commissioner. My next question goes to you, and it's on the contracts. My question is, what unique contractual challenges do power sector transactions in Nigeria experience? And how should power sector agreements be structured?
Oh, well. The Electricity Act gives us like a background on how these things ought to be, at least the 2023 Act. So the power purchase agreements, they should not lean too far away from what the regulatory statutes say. And the major complaint we have in a forum like Nigeria, if it comes to power, has always been the consumers. And in this scenario, the people closest to the consumers are the distribution companies. So these distribution companies, the regulation, the supervision, the overall day-to-day as to how their conduct should be policed, so to speak, in the essence of this contract. It has to be in a way and in a manner that the person that is benefiting feels that what is getting a fair deal from the contract is entering, and the people who are bringing these obligations also feel that they are getting a good deal from the table. It should be balanced, it should be fair. And when you speak to that, the regulatory clauses should be mandatorily taken into things have been taken it, because what we have here in Nigeria, let me even speak to some of the problems we have here. Most of the issues we face in these power purchase agreements are those people that are not happy with them. And it is only after the issue has happened that we hear of them. Renegotiation, compensation laws, tariff issues, tariff changes, issues surrounding tariffs are the major day-to-day that we see here. Let me create a real-life scenario, for instance. The famous Band A, Band B, and Band C thing that comes up day-to-day. The regulators tell them that if you cannot supply power between a particular minimum number of hours, you should automatically switch the person from a band to another band. And I think compensation and all that. But in practicality, it's a hard ask. It really is a hard ask. You have force majeure issues. You have issues that are outside the control of the discos. You have dispute resolution issues, termination. Look, I can suggest recommendations. I can sit in here, speak to that we should increase some flexibility in the indexes of the tariff system. We should speak more or come up with a system that compensates the consumers when they have tariff changes vis-a-vis when they have already taken agreements as to particular plans. We can say that the regulators should include clauses that makes the compensation mandatory, and it's not based on a complaint invocative system. They don't need to complain before the compensation should come. It should be an automated system. The compliance with both federal and state regulations in the instances where the states has powers to regulate these issues and the federal system, where Mr. Adafe has powers over here. It's the post-2023 scenarios that we are seeing. The Electoral Act is a 2023 legislation. The amendment that I was thinking was in operation, I've just been corrected that it's just the old news that we are hearing. But the structuring of the PPAs, it has to call for balance, it has to call for resilience, it has to be a compensation-based thing. It has to be something that the complaints of the people that are being forced on these tariffs has to be taken into consideration. At the same time, the distribution companies and the power providers also have to be protected here. There are a lot of instances that are not beyond their control. You have force majeure instances. So the $10 question rather is, how do you balance this out?
And I think that will lead us to a question that we can ask Honorable Commissioner, if I may.
How do you protect?
Yes. So I would ask.
Providers?
Yes.
How do you also protect the consumers here?
Mm-hmm, mm-hmm,
There has to be
A meeting point.
A meeting ground that is less radical or hostile.
Mm-hmm.
And it has to come, the infrastructure, the mechanism. That may be Mr. Adafe's forte. But for those on the consumption side, who the only time they feel they need to speak to the system is only where they feel shortchanged, not when they are taking advantage of the system. Because we cannot run away from the fact that lots of people in Nigeria, they try to just find the loophole around the system. We complain of tariff issues. We complain of not getting enough power vis-a-vis the tariff system that we are on. But I see a lot of people hacking this system. When these issues happen, it's a resultant effect of some form of unhappiness with the status quo. So, Mr. Adafe is here. The balance is something we should speak to.
Thank you. So I'll ask you my next question. And Commissioner Adafe, looking from what Leonard Sik has just said, I would say, how does NEC ensure compliance with license conditions? And what enforcement mechanisms do you use?
Okay, so I have just a bit of clarity on the last question, right? The power sector has a very complex contracting arrangement. And I do not think that can be discussed it's a course on its own, and there are courses on their own, right? Going from power purchase agreements, grid connection agreements, bulk purchase and supply agreements. So it's an interesting framework on its own. I think you may want to maybe schedule another session, maybe an introduction to power purchase agreements or something like that, just as a primer. Because I think if there's anything I want to get out of doing this job for the length of time I've done it, is to have more practitioners versed in this area of the law, because I think this is the next vista. And I think many people can become very successful legal practitioners just doing power. No, you asked the question of what do we use for compliance and enforcement, and I go back. It's the law, right? We are an administrative body set up by law, so we must act within our powers. And we must follow due process as an administrative body, because we are subject to the full gamut of administrative review of judicial review of administrative bodies. So as an institution, we use our laws, right? So when I resumed in this job in 2017, one of the first things I noticed was that the legal framework which we used then was the Electric Power Sector Reform Act, EPSRA. I realized that it was a very inadequate piece of legislation. It was an excellent piece of legislation to execute a reform, but because we hadn't done sector regulation as regulation in the past, NEPA was a standalone behemoth that wasn't answerable to anybody other than its employers and government. You couldn't sue NEPA. There were a lot of things you couldn't do. And so we hadn't done electricity regulation, and that flew into the preparation of that piece of legislation, EPSRA, that you could see that from a regulatory standpoint, it was quite weak, right? It was good. It was a good piece of legislation to say, okay, let's move from being a fully owned government operation to privatization. It did that very well. But for putting in place measures by which to regulate and superintend over an industry, it was very inadequate. The maximum fine for a breach of terms and conditions was 10,000 naira per day. And if it was a breach of a regulation, it was capped at 10,000 naira. There were limits to what you could do, right? The regulator couldn't intervene into the governance structure of licensees. So it was very inadequate. And in Ghana, at a retreat with the House Committee on Power and Senate Committee on Power, in December 2017, I said, look, Nigeria needs to have an Electricity Act that does a few things, right? And I'm happy that the proposal we made as a commission, right, became law in 2023 that creates a regulator that is empowered, that has the full gamut of powers to intervene. So I'll give you two instances. Before 2023, in 2017, when we resumed as a body of commissioners, one of the licensees, okay, we can talk now because there are judgments on this. If the then owners of Ibadan Disco were the same parties that also bought Yola Disco, right? And because of the issues in Yola at that point in time, they declared force majeure and they returned the asset back to the federal government and they had to be paid. But there were delays in getting a payment back. And the federal government put in place a fund then called the Nigerian Electricity Meter, there was a stabilization fund called NEBS, right? And Ibadan Disco got that loan from funds meant for Ibadan Disco. But what Ibadan Disco did with the funds was, rather than go and buy meters, they said they were, the investors said they received an interest-free loan to set off the debt being owed to them on the Yola transaction, right? You notice that Yola Disco and Ibadan Disco are distinct entities. They're not related in any way, right? So you get funds from the government to buy meters and to supply meters for customers in the Ibadan network area, and you do not exercise that issue. You now say, oh, I'm giving an interest-free loan to my shareholders, right? And your shareholders say, okay, oh, we're exercising a right of set-off, that when we do get paid, right, we will refund. That was rather egregious, right? So we sat down as a body of commissioners and said, no, this is something we can't tolerate. I looked at the law. Ideally, if this happened in a bank, what would the CBN do? The CBN would remove all the directors, right? Mm-hmm. But we looked at the laws and we thought that we didn't have the powers to remove. But directors have a fiduciary responsibility to act in the best interest of the company. But that is a breach of the fiduciary responsibility. So what we did as a regulator, and the regulator is also fiduciary responsible for the sector. So we couldn't sit behind and look at that happen. So what did we do? We issued an order, a very lengthy order, saying that an extraordinary general meeting should be convened and those directors who took that decision should be let go and another set of directors should be appointed, right? What happened? They went to court and the Federal High Court said, oh, we didn't have the powers to do what they did, right? And they stayed on until we got judgment in our favor at the Court of Appeal, right? But if that were to happen now, and I'll come back to another scenario where with what happened in Kaduna, right? Kaduna wasn't performing, right? And in 2023, right, with the under the auspices of the Electricity Act, what did the commission do? The commission suspended the entire board of Kaduna Disco, appointed an administrator, appointed a new board to run the utility until a new core investor could come in. So you could see that post 2023, right, the regulator has been given more powers in the Electricity Act to act like a regulator, right? But prior to that, we didn't have those powers. So you had to be creative in the mechanism we used to regulate the sector. But now we think that has changed now. So the law gives the regulator more robust powers, more enforcement powers, but in exercising those powers, we must follow due process. We must hear the other side, and basically things that if we do not do and someone challenges us in court, we will fail. So that's what we ensure we do. But we now have better tools to do our job as regulators than we did prior to the enactment of the Electricity Act.
Thank you. Thank you so much for that insight. So I'll ask you, Commissioner, how effective has it been to use your powers when powerful participants like government officers, when they violate these provisions? How effective has this power been?
I think you need to be a bit specific on. As far as we're concerned, the law is the law, and you need to understand the circumstances of the case. But we've not had any issues with dealing with people. So we don't look at who you are, right? We look at the facts of the matter, right? And we treat the matter on a case-by-case basis, right? So yes, the most difficult part of the value chain to regulate is probably transmission, because that is government. But sitting on our side of the table, we understand the constraints and we understand what the issues are. So it's not really because you're a government, right, that we can't intervene, but it's because we are working from a position of knowledge and clarity, that we understand what the issues are and what are the measures to address the issues from a legal standpoint.
Thank you. My next question will go to Leonard Silk. And Leonard Silk, I would say, what role would you say criminal sanctions should play in compliance?
Well, basically, whenever you are using criminal sanctions, it's a deterrent in the long run. The idea is let other people see what has happened to this particular individual and stay away from committing the same offense. Most of the time, speaking for the consumer's point of view here, the criminal sanctions, the threat of the criminal sanctions, electricity theft and the issuance of all these things on them, it deters. It deters. But why we talk of the role of the criminal sanctions, how have they actually been found out to have committed an offense, so to speak? The Electricity Act 2023, I know it donates the powers to prosecute to the Attorney General and those working under the auspices of the Attorney General's office. But do the discos know that? Most of the summons and notices they issue, they purport to get powers from the Miscellaneous Offences Act. And the Miscellaneous Offences Act has identified only 2 people to be able to even investigate under it. So when a disco comes up and sanctions an individual and convicts him to the payment of a fine, I begin to wonder and worry a bit. Do they even understand what they are getting into? Yes, I understand the essence of deterrence. We cannot keep stealing electricity and expect the system to survive. We cannot do that. It's just not feasible. I know that a lot of the electricity sector survives from subsidies. Government has to bail them out from time to time. Yes, Nigerians, we are crying about the weights, about the costs, about the whole idea of being responsible for how much we actually consume. But then again, when you are wielding the stick, it should be within the boundaries of the rule of law. I stand to be guided and I stand to be corrected, but that provision of the Electricity Act vis-a-vis criminal sanctions and having somebody found liable for energy theft, it's one aspect I think we need to sit down and look at critically. Because I speaking for myself, I worry. I worry. Because if the Miscellaneous Offences Act has come out and has stated clearly, these are the people that have the powers to investigate. These are the people that have the powers to actually determine if an offense has been committed under this act. And a disco on its own accuses an individual of electricity theft, there and then convicts the individual to the payment of the fine, or investigates, so to speak, because the allegation and the investigation go hand in hand. The determination of the offense is done on the spot, and the conviction follows immediately thereafter. And then there we have an issue. Practically, yes.
So I have a follow-up question to you. You've spoken about prosecution of offenses, and I would say, in your opinion, how can the legal system protect vulnerable consumers while ensuring that the discos remain commercially viable?
The deterrence must be very, very efficient. It must be seen to be transparent. The dispute resolution system that is in play must be sped up. It's a bit delayed. You don't expect a consumer who is complaining about illegal disconnection, as one of the most common ones, to wait 2-3 days or maybe even a week before the issue is resolved. And in darkness, if he cannot afford an alternative power supply. And some of them, the complaint is this: we do not get all the power. Come, I'm paying Monda Bandi. I don't get the powers that meet up to whatever I'm paying for, so I must make amends. They decide to also circumvent the system. They do the bypasses, they do the energy thefts. We can't run away from these things. That is true. But we must come up with a more robust system. Let disco operatives not bust into somebody's house like they have some statutory backing. In the middle of the night, I hear some estates in the FCT here, they're coming around 9 p.m. or thereabouts under the auspices of coming to do supervision. It begins to raise eyebrows. How do you determine there was energy theft?
Thank you, Leonard.
You did it, and he's convicted. And the man sees that, oh, what am I convicted for? A fine. The fine is how much? If he feels the fine does not fit into the offense, he'll keep doing it just to pay that fine and walk away. It's a slap on the wrist. We must come up with a proactive system that works for both the consumers and the investors. We can never run away from the fact that this is a commercial venture here.
Thank you for sharing those thoughts, Leonard. So, my question goes to the commissioner. How do you balance enforcement with keeping struggling utilities operational?
Can you repeat that question?
How do you balance enforcement with keeping